The intent of this brief video series is to promote basic understanding with regard to frequently asked questions about Pennsylvania's Procedural Safeguards Notice. This information does not consider all aspects of the matters addressed, nor is it legal advice, which the Office for Dispute Resolution cannot provide. For more information on these topics, or to speak with a specialist about your special education concern, please contact the Consult line at 1-800-879-2301. The focus of this video is disciplinary removals. This question series focuses on the general rules for disciplinary removals of a child with a disability. If your questions are not answered here, please contact the Consult line, where a specialist may be able to provide more specific detail. Note, though, that the following 3 questions and answers are a related series that should first be considered in their entirety. Can the school suspend a child with a disability? To the extent it does so with other children who have violated its code of conduct, the school can discipline a child with a disability. The law requires the school to follow specific notice procedures in disciplinary situations when the discipline involves a student with intellectual disabilities, or when removing the student from the current educational placement for more than 10 consecutive school days or 15 total per school year. Disciplinary actions may include placing the child in an alternative educational setting, another setting, or suspension. When circumstances involve the student possessing drugs, weapons, or inflicting serious bodily injury, the student may be removed for up to 45 school days to an interim alternative educational setting. During this alternative placement, the student must continue to receive a free appropriate public education, be enabled to participate in the general curriculum, although in another setting, and progress toward meeting IEP goals. What is a disciplinary change of placement, and how does that affect my child's program? Disciplinary actions become what the special education regulations term a change of placement because of disciplinary removals when exceeding 10 school days at one time, more than 15 school days per year, or when a series of short-term removals exceeds 10 days and results in a pattern of removals. The decision that a pattern exists is made on an individual basis and considers the following information: whether the child's behavior is substantially similar to that of previous incidents that resulted in a series of removals, the length of each removal, the total amount of time the student has been removed, how close the removals are to one another. Parents who disagree with such a decision have a right to request a due process hearing. On the date the school decides to change the child's placement for disciplinary purposes, it must notify the parent in writing, include information about the disciplinary action proposed, and provide the parent the procedural safeguards notice. What is a manifestation determination meeting, and when must it take place? Within 10 school days of any disciplinary action resulting in a change of placement, a manifestation determination must be conducted by the school, parent, and relevant members of the IEP team as determined by the parent and school official. This group must decide if the behavior was a manifestation of the child's disability, which means that the child's conduct was caused by or had a direct relationship to the child's disability, or that it directly resulted from failure to follow the child's IEP. For more information on these and other special education topics, please contact the Special Education Consult line at 1-800-879-2301.